start talking.
Thank you very much. Allow me first of all to salute the chairman and commander-in-chief of the National Salvation Front, General Thomas Luswaka, as represented by all of you, the attendants who are attending this gathering, this sharing together. I'm really very much happy to be together with you and to share this issue of concern that you, compatriot Lee, you have dealt with it in this all. Actually, you have. I could say, we could actually stop here. You have done it all in a very beautiful summary. You have painted it beautifully. Then, whatsoever efforts I may add, allow me to greet all of you attending this sitting, wherever you may be, despite the difference of time. I think this is really a good time to share together. Thank you. Thank you all compatriots and friends attending with us tonight and this evening or this morning. Thank you. Back to you, compatriot Daniel Lee.
Thank you so much, Justice Kukur, and welcome on the stage, compatriot Lorit. Justice Kukur, now that you've warmed up, I hope your vocal cord are ready to give us some of the answers we might be looking for. Let me start by asking you, and let me say this, Justice Kukur. The regime says it interrogated 83 suspects, discharged 76 for lack of evidence. And yet, the regime rushed to indict Dr. Riek Machar. From a legal perspective, how can a person at the very top be held while the majority at the bottom are released?
Thank you very much, Lee, for the question. Yes, it is. It may be useful for the listeners, for myself, as we all share this question. Let us remind ourselves of the basic problem that led to this situation, to this legal situation that we are discussing about. The fact, the incident that they describe as the Nasser incident that happened on the 3rd, that incident that is now the foundation of these charges, whereby, as you said, 83 suspects and then 76 were discharged for lack of evidence. And as we know, that that incident it has involved use of guns and so on, shooting, and therefore, in such a case, whereby Dr. Riek, who was sitting somewhere in the capital, and the incident definitely did not take place in Juba, it took place in Nasser. This is the theater where the action happened. And in such a case, we would expect that Dr. Riek is linked to this, what can best be described as military activity. So, should there be any criminal responsibility, it is attributed, it comes from where the military action took place, and then his role will now be seen as what we call the mental condition or the mens rea, like whether inciting or whatsoever, other than actions. Or if he was possible, unless he was also there, could be, which is not provided. So, the 76 suspects that are around, that at the ground level were discharged for lack of evidence, then, to leapfrog and indict the top leadership, who who has to be a kind of mens rea has to be proved, okay? And because the criminal, if you take away the 76 who are the actors in the theater, then you leave the person on top without legal criminal connection. I mean, I'm trying to, without any legal criminal connection, which is supposed to come from the bottom, from the ground, in terms of military activity. So discharging those people due to lack of evidence, logically and in the legal logic, then it renders no any legal connection. What if you ask yourself, what would be the legal connection? What will now be the basis of liability that flows upward from the evidence? And that is the shooting on the ground. Because in this case, the liability goes from below, upwards, and not down from the political suspicion. And therefore, in such a case, this is not law anymore. This is politics. This is politics, because the logic here is completely not following the legal logic, whereby the actions on the ground, where the ground was Nasir and the military activity took place there. So if you decide to render, if you decide to discharge those people that you have no evidence, then what evidence do you direct towards the other person, even if that person is a military person? What evidence now would you have? Because you need to have this link, as we go ahead. You need to have this link that connect the assuming, I don't want to talk at this stage, but assuming the bottom is no more there, then and the logic connects between the bottom and the top. So this is really contrary to the legal logic of criminal liability in situations whereby military action is, in a way or another, is linked to others who may not be at the theater, but who can be seen as having played a role, which is played a role other than actions. This is just in brief, trying to paint the picture and try to show that, unless you have the 76 people, charged, it would have looked reasonably and legally acceptable to some extent, even if baseless. But with the discharge of all this, it renders, the legal liability of no basis. On what will you support the liability of the person on the top, unless on political basis, and that is the political suspicion.
Great, great. Right. So, in other words, you're suggesting that these charges are less about law and more about silencing the political opponent and rivals. So that's what it is. Basically, that's what you're saying. Okay. Let's move on. Yeah. Thank you so much. Let's move on. One of the charges within this that was laid out against Dr. Riek and his colleagues is on murder charges. In accordance with the Penal Code of South Sudan, 2008, Chapter 16, Article 206 on murder states the following, and let me read it before I can ask you.
Yes.
Ever causes the death of another person, A, with the intention of causing death, or B, knowing that death would be the probable and not only a likely consequence of the act or of any bodily injury which the act was intended to cause, commit the offense of murder, and upon conviction be sentenced to death or imprisonment for life, and may also be liable to a fine, provided that if the nearest relatives of the deceased opt for customary blood compensation, the court may award it in lieu of death sentence with imprisonment for a term not exceeding 10 years. Now the question is, this article requires a specific thing. Murder under section 206 requires intent or direct participation. What proof must the regime show in court to legally tie Dr. Riek to those killings?
Yeah, thank you. Thank you, Ambassador Justice Lee. Yes. Happen. The act as reals, the act, the criminal act, the act which is prohibited by law. If you commit, it is a violation of the law, and therefore that you will have violated the law, you will have committed a violation of the law. But for this act to qualify as murder, the mental condition, the required mental condition at the time of the commission of this act must also be satisfied. And this is exactly where you mentioned, whereby they say whoever causes the death of another with intention or knowing, a lot of technicalities there, but generally speaking, that is the mental condition. What they refer to it as mens rea, the mind of the person at the time the act is committed, because there is no criminal responsibility unless that mind must exist at the time of the commission of the offense. In the absence of this, it cannot be, but of course it has been also developed through several decisions by court, so that it becomes much more clearer when dealing with the issues of intention or knowledge and so on. So for in this case, in our case, as the charge is directed against Dr. Riek Machar, who's the head of the IO, the actors' rears definitely does not apply to him, I mean, the commission of the act. The commission of the act, he was not present unless it is proved that on that very day or within the days from the 3rd to the 7th of March, if it could be proved that he was there and he participated in the theater where the act was committed, and then this would be that will first of all be the basis for the liability, and that the intention was also now as prescribed for the intention for murder, the intent that he intended to murder, or knowing that death would be a probable consequence, not merely a likely consequence of his act. And one thing which is missing here, and which should have been done by the pre-trial اللي هو إجراءات اللي يفترض يتم أمام Attorney General, and that is to lead to the charges so that it can be sanctioned. This is the now imagine the basis of this, and how do you relate this? I mean, any other person, definitely it is not a big issue. It's not a big legal issue to refute that there was no any act serious. There was no ما في مشاركة في ارتكاب الفعل الجنائي في ناصر. Okay. إذا ما لم يتم إثبات إنه دكتور ياك مشار كان موجود في ناصر في الوقت المعين اللي هو between the 3rd ليوم 7 وشارك بالفعل and then ترتب على ده نتائج معينة death, and that إنه the mental the required mental condition at the time of his commission of death, how knowing death was a consequence بتاع action بتاعه كان هو يعلم. Then if this could be proved, then this could now be a basis, yes, he could be charged under this. But the question would be now, how do you relate this? How do you relate this to a person sitting at the far, unless you can, but this under this section as it is, this section per se, لوحده, without relation to another, it is very strange. Yeah, without connecting it to another, it's really very, very, it's just very strange. Yeah, murder, because the state must prove the intent, okay, and then the direct participation. The government, Attorney General, if the government cannot, because mere allegation, that's fire. It's not enough to say you are charged under this. There must be evidence. This evidence should have been done in what we call the pre-trial at Irad Bitan, Attorney General, which without proof of those issues, it took the mushkila. The charges can collapse in law. Like in Taban.
That's correct.
Yeah.
That means that if such proof does not exist, then the murder charges legally is defective from the start.
Indeed. It's defective.
Yeah. Thank you. How are we going, our audience? So far, are we loud and clear, and are we getting, this is the nitty-gritty of the charges that, the myriad of charges that are laid out against Dr. Riek and his colleagues by the regime. So we'll continue. We have with us on the studio our Justice Kukur Lopita, Marino Petia, the former judge of the Supreme Court of South Sudan. Justice, one of the charges also that was laid against Dr. Riek and his colleagues was on conspiracy and common intentions. And that, of course, they've cited sections 67 to 69 from the Penal Code of Act 9, 2008, South Sudan. The law requires evidence of agreement or coordination under these sections, 67 to 69. I don't need to read the whole lot, but in a nutshell, it has to do with training as insurgent and bandit, saboteur, or terrorist. All of these, okay? So the law requires evidence of agreement or coordination. In your view, as a justice, has the regime produced anything that meets that burden? Or is it relying on political association? Justice?
Yeah, thank you. Thank you. Yeah, thank you very much. You know, as you read it clearly, these sections, the charges under 67 to 69, which are, you know, and they are really very, very important, and because just like as I mentioned earlier on, the these sections, which is 67, 68, and 69, both are just like what I mentioned earlier. It consists of actions or certain requirements which falls under what is described as criminal activity, criminal action. I mean, as opposed to the mind at the relevant time, at the time of the commission of the act. So, for instance, just you can relate it, make it much more easier to section 206, which was the murder. So, a group of activity, any action that you do, including omissions, you know, doing or not doing something when you are by law supposed to do, or you do something when you are by law you are not supposed to do. This situation is described in law as actus reus. These are the actions which are prohibited by law. These are the actions which are prohibited by law. Now, in this situation, like under section 67, there is a requirement, the mental requirement of conspiracy. And conspiracy is not an action. Conspiracy is also a mental condition. But conspiracy has to will involve at least two. There must be at least two. It can be more, but at least there must be two people, and these two not only acting, but also acting with a common intention. You know, nobody will be acting on his own differently, but maybe different instance also exceptionally. But at least under this section, there must be a clear agreement. I mean, call it agreement. There must be a clear join of mind, call it agreement in this case, and then this joint mind plan to achieve certain things, and that is the common intention. In the absence of this, then it cannot be. You cannot relate this mind to the actions which happen. So now, if you take this to as a charge against Dr. Riek Machar, now you need to relate and create a connection between the military activity that took place in Nasir which is, as alleged, attributed to the White Army. Those military activity, you must be able to establish a link, at least between one of them, at least, and with Riek Machar, and that and that becomes a conspiracy, and that there was a common intention to achieve certain things agreed upon, certain things which were in the mind of both the people on the ground in Nasir and Dr. Riek Machar somewhere away from Nasir. So this is the basis of, but the best place would have been where? Would have been in the pre-trial. Without the pre-trial, which is the trial, we call them pre-trial, the process before the attorney, al-ijrat al-yatim before amama niyaba. We call them pre-trial. This pre-trial is important to establish the charges. And without this pre-trial, it is not established just in front of the minister or by a report. It is established through, hearing and telling with evidence. They appear also before this pre-trial. In the absence of this, it becomes allegation. Without establishment of the sanction, the Kulubekun allegation, because it is not enough. Yes, you can use your authority and say I have charged, but when it is taken to court, an independent court will now look into the charges and evaluate the charges and see how the process of reaching it to become a charge or a sanctioned charge. And, in the absence of this, we have got really a problem. So conspiracy, as you clearly say, it requires clear agreement and common intention. It requires coordinated action. The common intention, there must be a coordinated action. See, coordinated action, in a way or another, there must be a kind of coordination. But the government has shown neither, and I'm saying neither because there was no pre-trial. Let us distinguish between the pre-trial and the court trial. The pre-trial is to establish al-ijrad amam an-niyaba to prove the al-tuhma. So what we see instead is guilt by political association, which is unconstitutional. Yeah.
That's correct. That's correct. Because that's what it is all about. And for the audience, just a reminder, Section 67 to 69, these are three sections. 67, it will be specifically is on purpose. 68 is specifically on intention. And 69 is specifically on participation. So take your time, go read it, and you'll find out that these charges on conspiracy that was laid against Dr. Riek and his colleagues was merely a political association. This is all that they were doing, which is a criminal conspiracy, and whether it becomes a criminal conspiracy under South Sudanese law, I'm not quite sure where is that, but this is what they've come up with. It has nothing, again, it has no legal basis to mount it as a crime. Justice Kukuru, Asharaf Moya, we continue قدامنا الليل قدامنا طويل النهار قدامنا طويل الصباح قدامنا طويل everywhere, everybody in where they are. The next bit, also one of the charges that was laid against the Dr. Riek and his colleagues was to do with crimes against humanity. And funny enough, the Article 186 of the Penal Code, which when you go and read that article, honestly don't want to read it because I will just be laughing. I don't want to read it. I want the audience write it down. Article 186. That section is the one the crimes against humanity is based on. It is really funny. This is South Sudan at its highest. Okay, so the minister speaks of systematic ethnic persecution. Now, even meet the threshold of systematic attack on civilians required by Section 186. Justice.
Thank you, Ambassador Lee. Wallahi, you mentioned it well. You reminded the audience, let them go and read Section 186, which is really a shame at this stage anyway, but I will come to talk about it. It is also the evidence that, lack of pre-trial, it is a disaster, and the minister, if the minister is whether is the minister doing this, I tend to believe that this could not have been done by any senior legal counsel, because misciting, quoting a wrong section, and for such a big crime, it is a real problem. Those of you who will read it, you will realize that it is about fouling water of public well or reservoir. هو تلوث مياه بتاع آبار أو المياه بتكون مخزنة في مواقع محددة أو بسميه خزانات بتاع مياه، مش الخزان اللي هنا، لكن أي محل تخزن فيها موية. This is about the offense بتاع التلوث. So it is not about, it has nothing to do with the nature of this issue. It has not been mentioned, there was issue بتاع تلوث بتاع موية أو استعمال بتاع سم عشان يلوثوا موية in the charges. Like, unfortunately, it was raised and related to offense, crimes against humanity. Shifta? This is one thing. And this tells you, yes, there was no pre-trial, and possibly this thing was done hurriedly, in a hurry, even by the minister, and therefore he quoted, he miscited, an irrelevant article. And it has gone. There's no way now it can be changed. It has gone, unless, of course, in South Sudan, I believe now I don't want to talk about judiciary at this stage. Let me first of all, I will come to that one. So
no problem.
The crimes against humanity are a part of the international crimes. Okay. Unfortunately, as I've been going through, I've went through the 2008 Penal Code Act. Despite, though it has become big, at least I was a party to the drafting of it, three of us. And, there was no offense of under the crimes against humanity, because we were waiting to embody the Rome Statute, whereby now, once we embody the Rome Statute, then Sudan, or South Sudan in this case, we would now embody all the crimes which are which depends on the Rome Statute. This is the unfortunate part of it. Although you will see that it has been spread, the amendments that happened to several amendments that happened to the Penal Code Act, it has taken some words, and spread somewhere in the Penal Code Act, but not taking the whole or not adopting the Rome Statute, because here say crimes against humanity, of course, requires systematic attack on civilian and persecution. But then the actual text in the penal code says whoever intentionally corrupts or foul the water of any public well, or reservoir commits an offense. This is the charge by the minister. But then the Rome Statute, which is Article 7, says, any of the following acts, it will indicate certain acts when committed as part of, and then they will say, then it says, goes on, as part of a widespread systematic attack directed against any civilian population. See, with then after that comes the requisite mental condition, which is with knowledge of attack, the acts include several actions like murder, extermination, enslavement, deportation, torture, and many other acts. But what has happened? South Sudan has signed the what do you call the protocol that allows South Sudan to embody this, but it fell short. It did not go beyond to complete the process, embodying it into the domestic, what they always refer to as domesticating the international law. And instead, it went out spreading some words, and you will never get any specific, but you get some spread here and there, which causes a problem, because the definition is provided already in the international law. But unfortunately, even so, he went wrongly and quoted an article which is irrelevant, because there was no issue of. In conclusion, crimes against humanity demand, exactly as you said, systematic, and it is a state-like machinery. It can only be done by state, But White Army, as you said, however violent, it is not a state institution. So it cannot, therefore, stressing the law, in that manner to criminalize all communities, rather than prosecuting individual responsibility, and this is the action here. توسع تخلي القانون بكل مطاط كده عشان تقوم you criminalize, you make all the people in the area who are not really a well-organized army, you want to hold them responsible. This is again is unlawful. This is again unconstitutional. Whether not beyond even defective ijraat, whether should there be any independent court, what an independent judiciary would do in such a situation where you confiscate the murder and then you give في كوك ولا في قزازة بتاع بيبسي مكسور, This is this is the situation with our minister, unfortunately. And
That's correct. And indeed, If there is any system out there, any definition, anybody who meets the definition of the systematic attack on civilians, that would be the SSPDF with its command structures and documented massacres that will fit legal definition more than the white army. Thank you so much for elaborating and explaining that. Thank you. We move on. Also, this is all, ladies and gentlemen, if you just joined us, we are talking with Justice Kukur, trying to decipher the myth around surrounding the myriad of allegations and charges laid down by the Minister of Justice in South Sudan against Dr. Riek and his colleagues. We are not here to judge, but we are here to make it clear because famous elected that the regime is trying to make بالنسبة للجنوبيين للمواطن. So they are assuming المواطن ما بيفهم. And المواطن طبعا غلبان همه كله دار ياكل يلقى اللقمة عيش بتاع اليوم وين. So this is why we are making this educative clearance so that you understand exactly دارين يخمونا كيف. Justice Kukur, one of those charges is treason. And that would be found, they based their treason charges on Section 64 of the Penal Code of South Sudan, 2008. Treason requires overt acts against the state. How is it possible to charge Dr. Riek, who is simultaneously a recognized partner in the peace agreement, the R-ARCSS? Legally, is this not contradictory?
Thank you very much. Thank you very much. You know, and شفت اللي هو الخيانة أو الخيانة العظمى, treason, this is the peak. And I think this is really what is in the mind of the state in this case. You are right. Treason requires يعني لازم يكون في overt act. You know, لازم يكون في أفعال, you know, في المسرح against the state. في أفعال. كويس. طيب, let us see what أفعال irrespective of mind. What are those أفعال اللي دكتور رياض عملوا? What are those actions? It must be actions. يعني don't look at يعني أفكاره يعني هو بيفكر شنو at that time. لكن were there any actions on the 3rd to the 7th of Nasir? Not in Juba. The actions must have taken place in Nasir, and this is where the scene of the Jarima. If in the absence of these actions, how is it possible now to charge any person, you know, of being responsible of actions, of criminal actions which are prohibited by law? If you commit them, you will have committed the act as real as the actions of treason. This is one. On the other hand, that these actions and in treason, they are intended to overthrow the regime. You know, by definition of this 64 through the amendment, it is to overthrow the regime. So okay, and Riek is part of this regime. So he is even assuming is correct. Then he is also overthrowing himself, who is simultaneously recognized as a partner in the peace agreement. Of course, you all of you are aware how the peace agreement has now become part of the constitution. So now he is accused of overthrowing the regime. And whether here the regime is the regime as led because of the symbolic leader or the regime that is a party to it. So this is really a problem. The actors rears by itself here cannot be satisfied, which has the actions and the scene. You know? So you cannot call a man a treasonous and at the time, you know, at the same time, you call him also he's a party, you know, with you. Can you and how do you reconcile between uh, commission of action to overthrow a regime that you are a party in the same boat at the same time, okay, with the peace agreement. The peace agreement has made the one boat, which was the constitution, has become one boat. Okay, the two are in the same boat. So legally it becomes a problem, and this is exactly takes us to what you describe as the contradictory and cannot be sustained. You know, it is cannot be sustained because of the contradictory nature of it, because there must be a proof of actions, and these actions must be proved in the in the theater where the action where the white army, you know, here you know ma issue with the agency under section 64 is not talking about the person you have you who is acting on your behalf. Is about you. For you to be liable under treason, you must have acted in the theater. Now, and this takes us to the question exactly as Ambassador puts. How logically now, how do you accept this legal chauvinism? This is chauvinism, you know. This is a problem, really. It's contradictory and therefore cannot be sustained. Cannot be sustained. And right. This is the whole thing is politics. Yeah.
Yeah. And thank you so much. Thank you. We are continuing on, and of course, one of those contradictories, one of the charges is that the charge in relation to terrorism and retroactive designation. We all know that the White Army was only recently designated as a terrorist organization by the regime. Only recently, okay? After Nasser Gidam, Ayam, Asabi Gidam. Can the regime legally apply that label backwards to criminalize leaders for acts committed before the designation? هل يجوز تطبيق قانون جديد بأثر رجعي لجريمة ارتكبت في الماضي تحت قانون وضع معين وكان لها أحكام معين، لكن جاء قانون جديد قبل يجرم نفس الجرائم اللي حصل زمان أو الحب الجرائم الموجود، وليتها هتطبق القانون الجديد على الناس اللي ابتدوا يرتكبوا نفس الجريمة تحت مظلة الجريمة العقوبة الجديد. انت بترجع تشيل العقوبة الجديد تمشي تطبقه في راس الناس اللي كانوا يرتكبوا جرائم من 20 سنة ورا، من 50 سنة ورا، تقول ما ده نفس الجريمة لسنا غيرنا قانون فوق نطبق لكم، بقى من 10 سنة بقى 50 سنة. So can we do that? Why is it in this way? Thank you. Justice, you can go on.
شكرا Ambassador Ali. Yes, طبعا they already designated the White Army was a terrorist organization. كويس. السؤال ببقى انه can the government legally apply exactly زي ما قلت the label بتاع backward, you know, to criminalize the leaders for action committed before the designation بتاع الاكشن ده. والوزير ذكر in one of the هنا انه هو بيطبق المبادئ بتاع القانون الدولي. القانون الجنائي الدولي international criminal law, it prohibits retrospective effect بتاع قوانين. You can only punish a person under a law valid at the time of the commission of the offense or at the time of the commission of the act اللي criminalize. يعني لازم يكون في law valid existing في الوقت اللي انت بترتكب جريمه، لكن انت ما ممكن تجي يعني تجعل جرائم لافعال تم قبل ما تشرع القوانين. ودي مبدا من مبادئ بتاع القانون الدولي where the minister is claiming انه هو يعني الاجراءات ده اجراءات وفقا لمبادئ ومعايير بتاع international law, which is a fallacy. It is not true. This is one أولا. retrospective هنا يعني الإفكت بتاع القانون يتبقى لا يجوز أصلا، ممنوع قانونا، ممنوع وفقا للانترناشونال لو إنه أنت يعني تعاقب ناس للحصل في الهيستوري. This was لاعتبارات يعني في الحرب العالمية الثانية، لاعتبارات معينة. المجتمع الدولي ككل وبالضمير بتاع المجتمع الأكبر يعني اللي ممكن تسمى إنه المجتمع الدولي قدر يعملوا استثناء عشان تحاكم بعض جرائم اللي ارتكب وقت ده قبل ما تكون في قانون، لأن حصلت حرب يعني هز الضمير بتاع المجتمع العالمي الساجد. عشان كده برغم من ده the world has gone back وثبتت حتى الآن في إنه non-retrospective effect ده لازم تكون it has to be يعني أصبحت من المبادئ اللي بتلقاها في الدساتير بتلقى يعني المبدأ ده أساسي جدا shouldn't be really هنا. وبالتالي what has happened في هنا I will talk more about it at the right time. It is really it is a disaster, another disaster يعني. So international law prohibits this retrospective criminalization. بالتالي you cannot declare إنه الوايت army terrorist group في 2024 لأكشنز اللي هم عملوه في 2023 إنه هم ديل terrorist. فده يعني بتبقى ده مشكلة يعني يسموه في قانون الاكس بوست فاكتور it is invalid يعني انت افعال حدثت قبل وجود الشريعة وقبل ميلاد القانون
التشريع الجديد.
ودي طبعا ده بتعتبر مخالف مش للقانون، معظم الدساتير
كل الدساتير العالمية
والقانون الدستور جنوب السودان تدعي انه هي بتطبق المبادئ بتاع القانون، المبادئ الانترناشونال لو، بالتالي وهي من بينها عدم تطبيق القانون بأثر رجعي. So it is a fallacy. So it is a fallacy.
Very good. Very good. احنا قبضناهم في الحتة ده. ده نطبق الموضوع بكلفة أساسا. The other thing also, when we read through the charges, we've noticed that there is double standards in the justice system. So, for instance, Major General Matthew Puljang was promoted in 2024 to command the SSPDF Force Division, despite prior allegations of child soldier recruitment and atrocities. Why are such men rewarded while opposition leaders are hunted legally? Their justice. What does this say about equal application of justice? Come up there.
This is another disaster. مش another, not beyond disaster. Disaster is a little bit better. You know, yani, recruitment of minors under international law is prohibited. It is a violation of international, yani, of child law. It is a violation of international criminal act. You know, and this is where it can even apply to you. You know, whether you are a signatory, whether you have ratified it, or you even did not domesticate it into your law. In the protection of human rights of children, you can be tried. You cannot therefore commit such an offense that will not give you any opportunity. You know, you cannot escape criminal liability. But in South Sudan, instead, you are promoted. You know, you are promoted. You are appreciated because of the violation of this act. Whereas cases whereby charges with Obasanjo, which are who was authorized, and then charges well established, could not be ما against هنا كنا لكن بيقدموا those accused who against whom there are no ما في pre-trial evidence, much evidence, no pre-trial procedures. And this is very important, as I speak along this. We're talking about mainly about the pre-trial procedure, and they are fundamentally حقوق بتاع إنسان. Without the pre-trial procedure, then what is it? And then exactly as you said, Ambassador, equality, this is the equality of animal farm. Some people are more equal than others. The equality in South Sudan is the equality of animal farm. Otherwise, how come this General Matthew Burjang would be promoted, you know, to a command, as you mentioned, Yani, to a high command, and against him an allegation of a crime that he cannot escape under any circumstances, even if he is protected within that fence known as South Sudan at the moment. So it's inequality, you know, while the opposition leaders are being hunted, you know, without any basis. The opposition leaders are being hunted without any basis. This say what about equal application of justice? When a man accused of atrocities are promoted while others are prosecuted selectively, you know, the message is clear. Justice is not blind. It is partisan. Justice, justice is supposed to be blind. In the family, like in this justice is also is partisan. That violates the principle of equality before the law.
Indeed. And that proves that the court processes in Juba are political weapon, not a justice system. Thank you so much for making that clear. Ladies and gentlemen, I hope it's Tumana and you're really enjoying this breakdown in nitty-gritty of the criminal charges that was laid out by the Minister of Justice of South Sudan against Dr. Riek and his colleagues. Like I said earlier, and I'll remind us all, this is to make sure, because this bunch of of the charges, when you read it through and you don't understand what is going on, you just go like, woof, this is up. But when you sit down and you listen to Justice Kukur, the former judge of the Supreme Court in South Sudan, in Juba, you get to understand that في عملية التغبيج حاصل. And of course, the regime is using that, knowing that 75 or 78 or maybe 80% of the people of South Sudan are illiterate. So this is what they are using against the people. Now, Justice, the due process and a fair trial. The minister claims that the accused have been informed of their rights. From your legal standpoint, can anyone in Juba expect a fair trial with independent judges, proper counsel, and transparent proceedings? If the judiciary itself is captured, how can it be?
This is really
let us understand how this works out.
This is really the due process, fair trial. This is the regulation. Demand to establish this due process, which should have started at the process with the investigation. Why was the Mafi Kalam and this pre-trial process with a charging? My charging will start from the low level of district attorney, the senior attorney, the most senior Mukansala, by that, and it can be appeal Laman Biasal the minister in our system, Mafi independent, Mafi independent attorney, it goes, but at least the safety net, our valve, there is a process of appeal. It can be appealed, right, deny. And if it goes and the minister overruled and sanctioned, at the is in the yes, at the is in the charge, yes, there is a charge, it is likely to be overturned if it goes through these processes. And this is the due process starts there. This is where the accused is charged in a process of hearing evidence adduced, in the defense without and decision is made subject to appeal by any of the parties, and so on. This has not happened. Otherwise, the movement that has happening now, it's happened just all of a sudden. The minister made the process done. and at which stage was this done? All this will, of course, be a question before the court. So, and of course, the fair trial requires that, and the accused, be given an opportunity to present his case, to be represented by a lawyer of his choice, to be heard, and then produce evidence, and then a case. At that level, it is about proving the prima facie evidence, بين مبدئية تبرر السير بسماع قضية الاتهام. At this stage, but this is a process. This is a due process, very fundamental. بدونه التهمة the charge بيكون بس كلفته authority بتاع police والنيابة and so on. Because the sanction by itself isn't إنه خلاص هنا ده في تهمة بينطبق عليه الشروط بتاع بين مبدئية. It can now be يرسل للمحاكمة. So in the absence of this بتبقى إشكال, which it's we haven't heard about this. there was no ما في أي كلام من lawyers إنه في كده. And of course, this is a problem. Now when it goes to an independent judiciary, أنا ما داير أتكلم كثير عن independent judiciary لكن بس أنا بحكي لكم كيس my colleague اللي هو this Justice Ruben Madol اللي هو happened to be attorney he was the previous Minister of Justice. We were together in a case كنا شغالين case this was the case بتاع 33 ولاية and so on. اللي فيه كان طلب إنه the Chief Justice Ambrose Ring the former Chief Justice must recuse يعني يجب أن يتنحى وكلنا أصرينا بالأغلبية إنه هو ما ممكن يعني يقود it was كان قضية بتاع محكمة دستورية. المحكمة الدستورية في جنوب السودان هي جميع قضاة المحكمة العليا بعددهم بالكامل بشكل دائرة. الدائرة دي بيسمى المحكمة الدستورية بتنظر في قضايا دستورية. فقعدنا كلنا وكان في واحد في سفر خدتنا بدل واحد the most senior من القضاة المحكمة العليا بتاع محكمة محكمة استئناف واكتمل عددنا. في أثناء ده تشيف جاستس كان مصر إنه هو لازم يعني يترأس. إحنا رفضنا وهو مشى للقاعة لوحده قدر يقنع يخوف واحد من القضاة ومشوا اثنين. وطبعا الكويس إنه الممبرز هناك هم كانوا واعيين وشافوا إنه دي المحكمة الدستورية ده اثنين أعداء ده ما محكمة دستورية. فحصل إشكالات وكده. فلما رجع من هناك مشينا للمكتب بتاعه قلنا له يا أخي كلامك ده خطأ. أصلا طبعا ده حسه ده ما جلسة بتاع محكمة دستورية لأن أنتوا اثنين ده ما محكمة دستورية. قال لنا اطلعوا امشوا في المكتب بتاع نائب رئيس. فطلعنا من مكتبه وانا قاعد في المساء بس واحد ضربني تليفون يا اخي كده شوف انت في تلفزيون انت قريب من تلفزيون ولا بعيد؟ قلت له يا اخي انا برا امشي شوف زميلك اسيا دوب فصلوه. this was روبن مادول ده بس لانه يعني هو كان he was the deputy chief justice. فهنا افتكر انه يعني هو لعب دور كبير في هنا رغم انه كل زول you have to put your opinion and support your opinion with legal evidence and legal precedents. I mean you have to justify why you think he has to recuse يعني أو يتنحى من رئاسة بتاع الدائرة لأنه هو عمل خطاب بتاع supporting هنا ده رئيس الجمهورية في زيادة عدد الولايات إلى 33 كان حسب. So there is no حاجة اسمه independence بتاع judiciary في South Sudan. يعني this is أنا ما دار شخصي لكن at least as a living evidence there was يعني ما كان في ده أنا بحترم في قضاة كويسين as individuals ولكن طبعا من قاضي لقاضي في حاجة بيسموه independent individuals الاستقلال الفردي للقاضي. ده أول شيء دي حاجة دي جزء أساسي بيكمل من الاستقلال القضاء كمؤسسة. لكن دي بالذات ما في بتاع الاستقلال الفردي طبعا بيتوقف أشياء كثيرة منها personality ومنها أشياء يعني دوف يعني personality باختصار. لأنها بعض الناس it is just like fighting in a war. يعني أنت بتكون في قضية كده بعد شوية جاوا الناس السكيورتي قالوا في كتاب من كده شفت أو يعملوا لك هدية and so on يعني فده so there is no independent بالذات المؤسسة يعني ما فيش أنت لو ما بتحمي قضاة بتاعك بالرواتب بتاعهم بطريقة بتعين إنه أنت you can appoint but you cannot dismiss. من أهمها هنا إنه you can appoint a judge لكن you cannot dismiss him, because if you can dismiss him خلاص يعني الدواف will never raise up. وبعد ذلك those people who will balance between والله يالي وكده وشغل and so on. لكن if you cannot dismiss a judge, وزي ما شفنا في الدول أخرى يعني يعني القاضي ما عنده مرتب، بيمشي بس يقول لنا ادينا الطلبات بتاعك بتاع شهر شنو، وبيدوا الاشياء الاساسيه وكده. So we have good young lawyers. لكن if in the situation that is ongoing definitely بيكون مشكله. و if you don't have a strong Supreme Court as individual وكمؤسسه قويه, it can then the whole thing is finished. That is therefore يعني أنا ما داير يعني أقول والله بكل صراحة يعني we do not have independent judiciary, because أنا شاركت في كذا ميزانيات بتاع judiciary. We have witnessed several things. في محكمة السيناء مشينا كنت مجموعة بتاع إضراب قبل ما يتم الدرجة بتاعتي، ومشينا ومطالبين بعربات وإيه وزيادة مرتبات وعدم تدخل في شيء. And then nothing was done. أو في النهاية المجموعة الجو بعدي they got dismissed كلهم 14، والمحكمة في إيست أفريقيا طالب إنه يرجعهم and nobody so it is really a disaster. And of course in the absence of independence of judiciary, then خلاص يعني you can buy your justice زي ما بيقولوا. You can buy your you can buy your justice, you know. So and now ما في pre-trial for this case. There's no fair trial. We do not expect ممكن يكون في حاجة صوري كده at the judiciary, you know, but you know the evidence, the evidence, weak evidence اللي جات من هناك, and then judges ممكن يتلاعب على إنه okay they don't apply the law proper, and then you just أو تاني ينتظر بس أيقونك بس أنا وافق. أي اللي جماعة ما داري المفروض يوافق بأسباب أو يرفض بأسباب، لكن يقول أوافق بس nobody will of course. وده كلها issues بتاع هنا lack of بتاع هنا independent judicial organ. So أنا ما داري أقول due process is really ما كلمات, not words on paper. Independence بتاع judiciary is also ما مجرد كلام من chief justice ولا قدات, but it is مؤسسة عندها أسس معينة, you know, أسس بالنسبة لمؤسسة وفي صفات يعني personality بتاع judges معين. In the absence of this تبقى مشكلة. And then access بتاع to counsel and transparency المبادئ الثانية اللي بتحكم وبتضمن process بتاع independence of judiciary أو fair trial. يعني all of them if they are يعني if they are not يعني guaranteed, then you know any other thing becomes a fair trial بيكون fiction, مجرد fiction.
Yep, that's correct. That's correct. Yeah. All right, Justice. من كلام that you've just elaborated, it is clear that the judiciary itself is captured, and if that is the case, then the trial is already null in terms of due process. There is no shak في كلامنا. شكرا جزيلا لك لوقتك. كنت تقدر تشرب موية ولا حاجة, you can reach out for your glass of water while we move on. يا جماعة هنا I hope you guys are كلكم you're enjoying what is doing here. This is the real nitty gritty that no one will tell you about things, and if you like this, we can get more and more of this type of discussions coming on so that we understand the bigger stuff broken down into small bite chunks so we can all get it. Justice Kukur, انت قبل انت طرقت لبعض مواضيع بالذات في موضوع انه the Minister of Justice was trying to say things like in terms of crime of against humanity, he was trying to appeal to the international community by letting them to believe that South Sudan itself is the laws in South Sudan is compliant and it is all the international laws to do with anything to do with crimes against humanity. And we فنتنا الموضوع في النهاية لقينا إنه ده كان كلام فارغ ما في حاجة نسيه هناك كويس. We've given one example كويس of that commander. So now if South Sudan is claiming to uphold Geneva Conventions, why then does it reject the African Union hybrid court, which would give impartial trials? What does this contradiction tell us legally?
This one, Jamil, it is really Geneva Convention as part of the ISL, as part of the international humanitarian law أو القانون الإنساني اللي منه قانون الحرب وإيشوز الخاصة displaced refugees and so on, الضحايا بتاع الحرب and so on, وإغاثة. So Geneva Convention is therefore part of international law, which is under international humanitarian law, الconventions والprotocols بتاعته. South Sudan in this case, yes, it is claiming, they are upholding Geneva Convention. And أسئلة السؤال really logical وجميل okay, if that is the case, since South Sudan is complying and adhering to the international law obligations, obligations under Geneva Convention, طيب الهايبريد اوكي الافريكان يونيون مع through الشغل الكبير اللي عمله بسانجو اوكي في كيسز جاهزه و establish الهايبريد كود، بل انت ودعته في الدستور ذاته انه تكون في هايبريد كود في ساوث سودان. طيب now يعني تاني شنو؟ ما خلاص you have hybrid code، قدم الناس ده اللي hybrid code عشان الناس يضمن الامبارشاليتي بتاع الترايلز. يعني how come كويس؟ فدي this takes us to كلام بتاع انه you do a process and you leave it halfway زي ما انا قلت قبل. تعمل process وتعمله halfway. You sign international convention, but you don't domesticate it into your system. شفتها؟ You don't domesticate an international obligation, which is a law, to your system in the same manner. وبالتالي so that you can, the standards are set under the international law, so it becomes now part of your domestic law. لكن انت بتعمل حاجه سياسيه انه والله we have signed this هنا we're part of this obligation. You can go and talk في UN في international forums and you claim and anybody you suppress the reality. Or you become very selective. You take some wording here and you spread it over your penal code act, so that بتشمنه كأنه as if it has embodied هنا، لكن you still remain not completing, not domesticating the real obligation, the real law, that is specific law under INAI. When you spread it out, you are not bound by the definition under the international law because it is not domesticated. You can now develop your own interpretation of laws through judges of your own. ترزية البيار في خيط كويس خيط نمرة كده وبدق نمرة كده. And this is the problem طبعا. مش لأن judges are weak, but if you create a situation where some weak personality موجودة في أي community في أي مجتمع, some weak personality who prefers نفسه first بطنه أولا, this type of people become vulnerable. شفتها؟ and then they will interpret توالي الحناية زي ما السادة دارين, which is the process. ده مشكلة. You know, this is the real problem. But هنا then this will take us to the contradiction. It reveals, you know, the government, the state is always afraid of impartial justice. Shifta, a strong judiciary depends on a strong judges of a Supreme Court who can now ensure how they build the future judges and a very strong laws and protection that any judge who does not, you know, who is not ready to work and follow the ethics, just get rid of him. You don't need a big number. Small number is enough. والله الجنوب ده كان بيمسكوا 3 قضاة يعني ما نم عدد ده زاد كم مرة, you know, جنوب بشكل الحالي even 100 could be more ذاته. لكن you know, you need to have an independent judicial system where you will guarantee impartial judges. Government wants control, not accountability. شفتها؟ لأن الحكومة داير يعمل control وما داير accountability. This is exactly, I mean, I'm talking of. And unfortunately, especially where you have now this type of government, طبعا tribal هنا بتكون the tendency is to dominate and not to.
But Justice, just in what you're saying, would you agree that refusing a hybrid court while prosecuting selectively exposes the government's intent to control outcomes, not seek the truth?
Absolutely correct. Absolutely correct. Because by refusal of the hybrid court, you are refusing impartial justice. You are refusing a court of no jokes, you know, no nonsense, that follows the law to the best of their knowledge, that abide by the domestic laws and the domesticated international laws, and that they really do the justice to the best of their knowledge. The Mayer without following Kulal principle. Like Vitali, of course, the best solution for the government is to abandon and refuse that constitutionally established code, and then opt to any other to the ordinary court that will now take you like the Supreme Court. The Supreme Court has been replaced there by hybrid court. Like no, because طبعا بتعرف جداد ده هيجوا من وين, because they will be hybrid, you know, جاي هيكون من هنا لحمراس, هيكون من هنا من East Africa, من beyond East Africa and so on. وبالتالي it is a real يعني مشكلة. يعني people are exactly كلمة تغبيش. You bring the Geneva Convention to mislead, you know, to send a wrong signal. كلمة حق أريد بها باطل عشان تخلي الشعب
exactly
كده. أنا هنا يا أخي بمعايير بتاع جنيفا كونفنشن, أنا هنا بالقانون الدولي الإنساني, قوانين الحرب, أنا هنا بنطبق جنيفا كونفنشن وكده. لكن وين؟ This is a real, دي هي مأساتنا والله, هذا النظام الغاشم.
ده حقيقة. الجملة اللي تقولها أخير, كلمة حق أريد بها الباطل, it's the most strongest phrase you can use in law. Thank you for bringing it and reminding us and reminding the audience as to this is what the regime is doing. Let's move on and let's tackle some of the things to do with these charges, how it was brought, the news was brought to the people of South Sudan. So, timing and politics. 3 charges come just as R-ARCSS itself is faltering. From a legal political perspective, is this timing accidental or deliberate? What do you think?
Yes. I thank you very much for the question. You know, to be able to do justice to this question, you have to take into consideration the context. You know, yani absence of pre-trial, and therefore centralizing the whole process لحد كبير just in front of the minister. يعني should there be any زول بيكون عمل شغل بعد ما المينستر بس عمل اللاين بعد ما جابوا له الكيس من police. طبعا police just there or whoever is involved in the process ما بيكون police ذاته ولا المهم جا خطوه بعد داك نقولوا في يوم التحري. We understand we نفهم الحاجات دي كله, ولكن the context هو التايمينج اللي حصل. يعني if you look into the calendar with the country, yes, this event has happened في مارس between the حسب ما هم بيقولوا on the 3rd to the 7th of March في ناصر. أنا هنا الآن في شهر 9. And if you look يعني across the calendar, يعني somewhere we're supposed to have election. And يعني this the so-called the agreement that despite its defect, the fact that it has given طبعا the worst thing طبعا is أنا ما داري أتكلم عن ده, لكن the fact that this agreement has given power to one person, one group, one person يسمى SPLM in government, and it has given a very small portion to Hinai. This person known as SPLM did it in a manner to ensure that, you know, to ensure the result. This is my own, to ensure the result. But how come to ensure the result with that will but then after getting annoyed from the other person known as IO, the IG therefore look for a solution how to you know يعني الإخراج بكون شنو. And I think this is my own wild thinking. Maybe some of the lawyers now, you know, you better make it legally so that, you know, you remain within the ambits of the international community, and of course you use your sovereignty and you give a fictitious independence of judiciary. You tell the world that you have an independent judiciary. Okay, and at least now you have a process that has invited so many people, you know, to come and then get at least a less what do you call less difficult, you know, a partner, and you continue with the revitalized, because the revitalized as it is the most comfortable to the regime. But I think the scientists of the regime realize that, you know, even with the big share, it is still facing some difficulties. So the legal solution was possibly sought. And therefore,
and then the legality, given the fact that judiciary is not independent, and they might have reached a solution that we can deal with the individuals who are there. ما في مشكلة, you know. It is always
okay. So based on your explanations there, Justice Kukur, would you then argue that this case is more about breaking the R-ARCSS itself than about seeking justice for the victims in Nasser?
It is true. It is true. It is by actually it is first of all it has failed to satisfy all the requirements. Yeah, as the last report, as it was saying, at 17, assuming now it has gone to 20%, so 80% of it, after several extensions, is not implemented. Definitely, any logical conclusion that this is intended to do away with the R-ARCSS is logically valid, because you cannot, after several extension, you know, if you really mean business, even at that, even as it is, with all its defect. But even with all its defect, it seems it has caused them, they felt maybe through their imagination about the White Army and others in the field, in the Sudan, the geography, they felt, you know, this is a problem. Therefore, they feel that they have to silence any political partner who is with them, and therefore silencing this group and getting any other group, or in fact, getting any other group will now be just invalid, and then this will mean the collapse of the agreement, which as already realized by the partner to the R-ARCSS, that it is dead. It is dead. What is now happening is just to show the world that, you know, it has died through this evidence, which is adduced by court. It's now the court making the decision, not the government. You know that. You are right.
Thank you so much. Yeah. Thank you so much. And thank you, audience. If you've just joined us, we are actually talking to Justice Kukur, the former judge at the Supreme Court in South Sudan, the current member of the National Salvation Front Leadership Council. We are talking about the myriad charges laid by the Minister of Justice in South Sudan against Dr. Riek and his colleagues. And we are trying to break down those charges into bits and pieces, because we've realized that there is something fishy about it. And it is the victim in these charges that is laid is not the victims in Nasir alone, but it is the entire population of South Sudan. So you joined us, enjoy the interview. All right, Justice, from what we've just been talking about 2 seconds ago, or 3 minutes ago, or 2 minutes ago, the government claims to speak to victims. In law, how do we balance the victim's right to justice with the accused's right to a fair trial, especially when trials are weaponized politically?
Okay.
Can real justice actually for the victims ever come from selective prosecutions that ignore crimes committed by government forces? So what do you think?
Yes, this is a good question. You know, victims, not generally, victims, as a matter of law, they deserve justice, but not politicized trials. Victims, they deserve justice. Okay? And through justice, balances, the victims' rights with the fair trial rights. Because the accused and the victims, in this case, it is the fair trial that will really, and which I tend to believe that it did not happen. The due process of formulating the charges, the pre-trial, this is fundamental. This is fundamental. So that this prima facie evidence البينة المبدئية ده اللي بيتم الحصول عليها في الإجراءات يسمى أحيانا إجراءات ما قبل المحاكمة، اللي هو الإجراءات اللي بيتم أمام وكلاء النيابة، بتمشي over 3 stages. المرحلة الأولى قدام النيابة الأقل درجة الديستريكت في الاريا اللي تم، وهكذا، والثانيه بالاستئناف، والثالثه الاخيره، وبعد ذلك بتمشي لوزير in some cases. وطبعا لانه وفقا للقانون so وزير has limited powers, but in the absence of this then the minister has everything. So here then it is no more justice, it is a politicized kind of process, due process, So true justice that is supposed to balance the rights in between the two in the fair trial is absent. So when the state, in this case, the state will do what? Will organize the trials, Zato, Shifta, and both the victims and accused technically will have been denied the justice or lacking the interested party in this case is of course is عمل نفسه covering نفسه كأنه victim. In this case, the state who is represented by the attorney in the cases بتاعنا اللي ما في independent attorney general, will pretend كأنه is denied, لكن it is in fact weaponizing the trials, من البري ترايل قبل المحاكمة وأثناء المحاكمة due to the absence of independent judiciary, and that is the unfortunate part. In this case, then the legal system or the judicial system, the legal system in this case, in the sense of the narrow meaning of the legal system, بمعنى attorney general, police, attorney general, and judiciary, then they are just weapons in the hands of the government used to, to fight the opposition with. And this is the unfortunate situation that is taking place in South Sudan. And that the regime
indeed. Yeah. Indeed, you've made it right. These are the unfortunate situations. Talking about the victims, Justice Kukur, human rights reports have documented SSPDF atrocities in places like Lir, Yei, Juba, and other places in South Sudan. Why do you think the government never charged its own commanders for crimes against humanity? But guess what they did? They jumped on Dr. Riak and his colleagues and they laid the charges.
This is exactly, Shukta, you reminded me of one thing. But before I talk about that thing, just let me come to, yes, as you mentioned, that, and you are right, several human rights violations report, it has been documented, against the SSPDF, even when it was still SPLM, before the name was changed. It has been documented atrocities committed by them beyond Ler, Juba, and many others. But there was no any
any charges that the government, not only reluctant, the government did not do it, did not do that willingly, and it wasn't done. There was no any charges against its own commanders, those who committed crimes against humanity or even war crimes, crimes against international law or against international criminal law. Unfortunately, this is happening when now this has happened and the government has not done anything. And while just immediately without due process, it has indicted Riek Machar and some others, charge and this. Imagine this. Here is a report, but the government did not do, and definitely this amount to intentionally undermining the international obligation that the government is at least has committed itself to some extent. Not domesticated, but it has signed, and in certain areas it has also, and the human rights law. And this tells us what exactly it takes me to the Second World War. The victors' justice or adala bital muntasir. In our case, yes, is adala bital muhaymin. The one who is in control of the machinery of the whole country, economically, politically, everything, and using the traditional innate power of and exploiting the innocent ethnic origin that it claims that it is representing while they are innocent. This is the justice of Victor. The justice Adala Bital Zol al Muntasir, who is in control, it is Adala with impunity. انت بتعمل بترتكب جرائم ولكن بتفلت من القانون. وقد لا ما بتفلت من القانون بانه قانون قدامك مؤسسات باليه ما عندها اي اسنان. You will never do anything to you. This is the thing. And then you exploit the international situation بتكون حاصل يعني. This is really unfortunate. The selective application of crimes against humanity ده كله, it is because of this power, and this is really the problem intrinsic في nature بتاع intrinsic nature بتاع R-ARCSS. You have given the control power كله ل IG with the tendency to use the tribe, the innocent Jesh Bital tribe, who are innocently made to believe that, so the Adala Bital Muntasir, and Muntasir Bimana, he won the article, the R-ARCSS, it is really unfortunate. It is miserable, and it will continue until الناس تصحى من النوم وتثور. There's no way يعني ما في حل there's no ما في area رمادية في النص أصلا ما في. أخواننا all our brothers are exploited there, and all others are not exploited. There's nobody more exploited في South Sudan. Everybody must wake up. ما في طريقة أصلا. There's no
that is
halfway.
true justice.
There's no halfway. يعني Adala has a price, and the price is really blood. ما في أصلا ما في. أو
That's true.
Then we continue, تستقبل ويمشي تدق المرتب ويحددوك اعمل الحكم ده وتعمل that was the choice. يعني كنا ممكن نقعد ونصدر احكام ده او وتموت.
Yes, exactly. Dear audience, you're hearing this from the mouth of the horse. He was there. He was in the center of it. He could have made the choice to be the instrument of the dark, but he did not. You just heard it from him. So I'm glad that you're listening to Justice Kukur, someone who is not imagining, but he is actually talking from what he has practiced as a judge at the Supreme Court of South Sudan. Justice.
Yes.
One of the things that got my attention into the myriad allegation and charges that was laid out by the Minister of Justice of South Sudan against Dr. Riek and his colleagues was how they were trying hard to push the narrative of transparency in the trial proceedings. So what did they say? They said that the media may attend the opening and the closing sessions. Now, Justice, help me out. Maybe I forgot the law. Legally, is that sufficient for transparency? In such a high level, high profile case in the country? You bring the media in when you're opening, blah, 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 finish. You don't get them in, you don't allow them in again until the day of the judgment, when the sentences are being handed down. How is that legal? Help me and help the audience out to understand this, Justice.
I thank you very much, Ambassador. Justice Daniel Lee. Justice must not only be that. Let me just reiterate المبدأ ندرسوه لنا في من سنة أولى. Justice must not only be done, but must be seen to have been done. شفت دي المبدأ. يعني ما في عدالة بتتعامل وباب بتاع المحكمة مقفول أو ممنوع إنه الناس تخش. القاعدة العامة إنه المحاكمات يتم بشكل علني للجمهور. والاستثناء there are only exceptions. morality إذا كان في إنه قضايا اللي بيمس morality مثلا في قضايا خاصة بأسر مثلا
قضايا بتمس العرض.
نعم. وأحيانا بتكون في قضايا يعني ذات طبيعة كده يعني مثلا مشكلة أمنية. أوكي يعني وده في حالة كمان إنه الدولة ما يقدر يعني يعمل اسم شنو يعني this has been interpreted to the very narrow extent بتاع هنا ده to the extent إنه almost بقى ما exception. الموراليتي ده في حتى المصلحة العامة ده بقى because it has been abused, it has been also interpreted through سوابق to the extent بقى almost ما في. لأن الحكومة دائما in power will always claim إنه المصلحة العامة هتتعرض للضرر وبالتالي يصيروا chief justice إنه يا أخي خلي القضية ده يكون in camera يعني سري ما تكون open. فالادعاء بانه الجلسات الاعلام يحضر opening and closing is مخالفه للقانون ومخالفه للدستور مخالفة لهذه to this international principle بتاع transparency. Justice must be seen to have been done. شفتها؟ والexception ده let us follow the exception as يعني زي ما نحن تبنينا ده، ومبدأ ده موجود في الكريمنال بروسيجر. المبدأ ده موجود وفي السيفل بروسيجر انه المحاكمات يجب ان يتم علانيا. الاستثناء it is in camera او يعني غير علني يسموه in camera ده. وبالتالي اي كلام انه الاعلام يحضر opening و closing كيف يعني؟ يلا في النص هنا ده، ما this is lack of transparency. فده this is يعني ده كلام ما، ده كلام بيخالف القانون، ده كلام مخالف للدستور ذاته، لأن الدستور اتبنى المبادئ ده مأخوذة من يعني embodied في الدستور. مبدأ بتاع علانية المحاكمة هي because هي مبدأ عالمي، يعني ما بس في قانوننا يعني، لكن هي مبدأ عالمي. جنوب السودان اتبناه وشكله موجود في القوانين بتاعنا وموجود في قانون بتاع البينال كود اكت بتاع 2008. فالسكرسي يعني ده ديسجايز بس. ده معناته شنو؟ انتوا يعني ما ده هسه ده ما علانيه، ده اصلا بس يعني اسم يسموه شنو؟ ده هي سكرسي بطريقه ده اسم الدلع بتاع
exactly. That's true. لأنه what happens is في المرافعات الافتتاحية والختامية ده المرافعات وبس، لكن مداولة الحيثيات بيحدث في النص هنا. وده nitty gritty of what is it, presenting the evidences, discussing and أرفض ده وأقبل ده وما تقبل ده. This is the real part, is the one the media is not allowed to attend. Thank you so much for making it clear. Ladies and gentlemen, you are listening to Justice Kukur, the former justice of the Supreme Court of South Sudan and the current members of the National Salvation Front Council of Leadership. And we are moving on, and we are about finishing with this exposing this myriad of charges that was laid by the Minister of Justice of South Sudan. Maulana, let's move on. Let me go through to this, because we have to come to this. If we don't get this one, honestly, then something is not right, because the whole thing was based coming through this. They laid out charges somehow gave us the idea that there is constitutional protections. So are there constitutional provisions or protections under R-ARCSS that shield political leaders from selective prosecutions? If so, is the government violating its own constitution by pressing these charges? Because if that is the case, then this is all of the whole charges amounts to unconstitutional actions and legally voiding the case. Then there will be no case. What do you think?
This is a very good question. Another good question. Of course, as we all know, I think it has become like a common knowledge, or we call it judicial notice. You know, the R-ARCSS, or the revitalized agreement for the resolution of conflict in South Sudan, it has been embodied in the Constitution, and therefore it has become part of the Constitution. So the Constitution is not read in parts. It is read as in whole, as one whole. So it is not read in the sense that what that part of Constitution which is originally R-ARCSS applies to IO, and the other part applies to IG. The whole of it applies to both. It has become one unit. And as unit, yes, there are principles that protect any citizen. Like, for instance, the presumption of innocence. You know, any person is an accused person is presumed innocent. You know, until it's proved in the court, is proved beyond reasonable doubt. At the level of Attorney General, is proved to the level of what we call prima facie evidence, أو بينة مبدئية, which justifies the continuation, which justifies why the case of prosecution should be heard. And this requires a process, pre-trial. This is one. And therefore, all citizens in South Sudan who were previously IG or who were previously IO and now they all are citizens. Therefore, they enjoy the principles of equality. You know, there should be no any selective prosecution in the manner we have shared before. You know, there should be no any selective victimization or attitude of a kind of victor justice. You know, this is really victor in the sense if you happen to be in control of the whole power. And of course, I don't want to, this may not be the right time to talk of whether really agreement is important, you know, agreement as a tool of resolution. I mean, this is outside this, but the fact is that IO has been victimized as a result of the power arrangement within the R-ARCSS, and therefore the selective prosecution. You know, there has been a lot of amendments. You know, in the unfortunately a lot of amendments, several amendments in the Constitution, which has rendered also this situation has rendered the group under Riek Machar vulnerable. So the Constitution and the R-ARCSS, of course, it provides immunities and protection, okay, to all political leaders. But as you can see, this even immunity, it has not been used in a manner that reflects the principle of equality, the immunity of constitutional senior leaders in the country, senior leaders in the country, as may be prescribed by the law, you know, which is derived from principle in a constitution. This has been disregarded. This has been disregarded, as you see, through a lot of amendments. So by ignoring these issues, and therefore, you know, the selective, as we mentioned earlier on, you know, without charges, with the wrong citation of charges, and without embodiment, without domesticating certain principle or international laws, and yet you hold people responsible for under those laws. This is really a disaster. This is a disaster. This is not only violating rights, but also violating its own constitutional order. It is the order that is supposed to protect both. But because of the principle of selectivity, you know, and this selectivity is derived from the one holding the bigger power, you know,
And this was the risk, I think, that was anticipated by many. This holding of the bigger power gave justification for the selective attitude, of enjoying certain constitutional rights, immunities, and protection, charges, pre-trial, and so on, the process of it. So, the government, the state, the government under Kiir is not only violating the rights, which is, but violating the Kiir constitution, its own constitution. So see what I see this, Yani. How do you describe this politically? Constitution as a political document that is only put in a legal form, certain principles which has now gained the power of law, but yet you do not you apply it in a manner that, in a selective manner. You apply it against your opponent, assumed opponent, who is a party with you in the same boat, and then which the question is now, what will guide you really? What principle will guide you? Everybody actually in that boat, including the IG themselves, they are not safe. Once they get rid of all the IO, the IG will not be safe. The principle will continue. الثورة تأكل بنيها. Because they have no principle. ما عندهم مبدأ يتكي عليها ولا بيحترموا. كله. This is the disaster.
That's true.
Yeah, this is the real disaster. Yeah,
thank you so much, Maulana. Thank you so much, Maulana Kukur. Finally, I believe we are coming to the end of this, analyzing what is happening here. So if this charge is based on what you just elaborated in the last few minutes, if these charges proceed, what is the legal and political impact on R-ARCSS, even though in the past few days we heard a statement of the acting chairman of the SPLA IO, in abandoning the R-ARCSS. Yeah. Can there be a peace agreement when one party's leadership is dragged into politicized trials? So what do you think? As your final remarks.
Yeah, thank you very much, Justice Lee. The legal and political impact on R-ARCSS, if the charges really proceed. Of course, the charges will proceed. I mean, this is my own thinking, given the independence of judiciary, without regard to I'm not concerned at this stage with regard to the individual independence of judges. I don't want to, because this case is going to test them really. It's going to be a real test. If we have independent judges under the current regime, and that they are working in a system which is not independent. If we have individual judges who are enjoying the individual independence, which is aspect of independence in institution, that one has to be tested. But given this institution as an independent, I would not expect any. I would expect that the trial will continue, and there will be conviction, and of course as a result, because white plus one plus one is equal to 2. يعني a week قضاء غير مستقل ما ممكن يجيب حكم يعني نزيه. بغض النظر عن الافراد you know يعني this is يعني عشان كده انا ما داير اتكلم عن الافراد لان anyway يعني it is really very 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 difficult يعني the history also is an evidence the history which is evidence القضايا اللي قبل كده قضايا دستورية محاكم بتاعنا ما قدرت تقيس قدامها أنا عشان كده أنا بكل شجاعة أنا أثق تماما بمعرفتي لاستقلال المحكمة إنه القضية ده logically the logical conclusion it will be conviction ولكن الشيء الأساسي إنه once the case proceeds and conviction تم it will only then ascertain just the death already هناك طبعا this is what the government wants and who are this death will now be pronounced by the legal institution this is legally طبعا كويس but politically of course politically the good thing politically and I think the political action is already the IO has realized that the government is not genuine and therefore they have at least taken the right stand. They have realized the right thing that there is no politics, no fair politics in a process where the power arrangement is not fair. Aslan, they have realized this, and therefore the declaration made, which is a political declaration, at death, the government is just trying to يقول إنه نحن ما قتلنا لكن القتلوا attitudes بتاعهم which is against the law. الهم ما احترموها في المقام الأول. So the Inai will come to an end. The peace for the second time now will just be proven the death now عشان beyond reasonable doubt زي ما الناس هنا حتى اللي بيتشككوا من الجماهير بتاعنا والشعب بتاعنا المساكين في الجنوب اللي بيفتكر انه والله يمكن هنا ده يعني الفتلايز ده حتصحى من الموت وحتى ولو عملوا لها هنا أهلي بكجور عشان يجيبوا أفراد آخرين they will follow the same thing شتا they will follow the same thing بتاع إنه selectivity ده شفتا يعني they will قبل ما يجي ياكل نفسها they will يعني إلا هم يسبقوا جزء من أيجي وبعدها يجي يموتوا موت الجماعة هرس بعدها يجي يموتوا مع بعض but nothing is expected أنا unfortunately بيقول ده إنه these charges they go ahead the peace agreement of course will die now beyond reasonable doubt and you cannot build peace by prosecuting one side into silence and justice if the justice become fair peace will not hold at all and the challenge now is on this whether they can really prove we have individual independence of judges في المحكمة العليا بتاع جنوب السودان. This is the real challenge. Yeah, they either bite the bullet or they choose to to make fallacy, false justification or but it will, like in the good thing, history, it will be read and you need to have evidence. There's no way to play around. It will be seen والأحكام أجيال ورا أجيال generation will examine whoever allowed himself, who have الاختار بطنه بفتكر إنه that's all. This is it. It is here بين الحق والهيمنة الضيق اللي بتستغل الethnic group it is ده our judges يكتبوا history
the Chief Justice and the Deputy والآخرين and you know them في مجموعة بسيطة اترقوا قريب لكن المجموعة اللي كنا مع بعض this is the history is really watching them. They have to do the right thing. Otherwise, history also will not forget. You know, it will continue يعني forever. الأحكام اللي أنت بتصدره و كنا بنقرا كل الأحكام you can see شفت إنه قاعد ده اشتروه مستهبل جبان. You will see في أحكام بتاعه. That's the situation. The piece just will now die bigger legally, but it has died already. It will now die legally beyond reasonable doubt. Politically, the option is done, and I think I really legally appreciate this political decision, because this political decision by IO, it has awakened. It shows, they have awakened. They have realized the detrimental arrangement of power in the R-ARCSS. And so it puts everybody on task. The international community has to be on task. You cannot give power and you think, this can keep the balance. Maybe in a society with a diversity, fear, a lot of ignorance, people can easily be exploited. زي ما حصل يعني. Peace, unfortunately, there will be no peace. There will be no peace, until further notice. Further notice is until Kiir and وكل النافعين بتاعه يمشوا مزبلة في التاريخ. There's no way. أما هم فتحوا عيونهم وتراجعوا تماما وتحملوا any accountability and sit with everybody في الشجرة الكبيرة where we, the people of South Sudan, can sit together and decide, يا جماعة, how can we really نقسم العناية? And then we answer the big questions, يا جماعة. Can we really live together عشان peace يقدر, so that we can hold peace. لكن peace بتاعوانتا إنه ما في طريقة. You can grab all the land. You can do everything. History have shown إنه land grab في Nigeria grab for 40 years جاء كسروه. ما في حاجة ويل أحسن أقوى من ويل بتاع شعب. إذا الشعب يوما أراد الحياة فلا بد لليل الطويل أن تنجلي. That's
exactly.
There's no way it will go. Time will come وكل شيء كل شيء عنده ثمن. هنفقد كثير ولكن that time for sure will come. أجمل.
That's correct.
تفتح الزهور ونبتسم, and you don't need that. نمشي لأوغندا زيارة, نمشي لكينيا زيارة, مش لاجئين. And we return back from الكانتريز بتاعنا بتاع second citizenship أو nationality. We go to country of origin بتاعنا ربنا خلقوا لنا ونعيش بكل أمان كده بكل القبائل. ما في we are talking about young council of elders, not Denka. لكن اللي زول الدار التبر المستفيد will always meet إنه يا أخي أنت قاصد أنا هنا. ما هم سموا نفسهم young council of elders. المجموعة ده ممكن ما يزيد من قول هم 5,000 which may not be true. زائد النفعين بتاعتهم من كل مناطق بتاع الجنوب كله 2000 ولا كم 7,000 ده. Time will come. Look around, شوف what is happening all around. شوف Sudan. Look around. It is coming. شفتها؟ ده كله من أجل injustice. أصل شفتها injustice. This is the good thing إنه أصلا it will. There's no way. ده كله it will come. It will come. مهما كان الثمن دفعنا الثمن مرتين وجاب دفع كم مرة it will time will come إن شاء الله أن تبقى دنيانا أجمل وأحسن بكرة وننسى ده كله and then we begin. ولكن يعني أشياء كثيرة الناس بيقول كان forget من أجل السلام بس let us accept ourselves. let us يعني ما في زول that ما في زول يعني no animal farm equality. There are no tribes more equal than others. يعني as we speak يا أخي أنت بتسمع حاجات يعني لو أنت قلبك ما قوي طبعا، لو قلبك ما هنا ناس كتار قاعدين يموتوا really. لكن that time will come. Let us remain hopeful. لكن let us do everything possible يا جماعة. Let us really نربط بطولنا. Let us do everything is possible. شفت if we share الجوع بتاعنا زي أخواننا on the ground بس حاجة بسيطة بس if we share يوم يومين بس and we do it والله you will see هنحقق السكند ليبريشن بأسرع ما يمكن، وبعدك بنقدر نحقق justice judiciary اللي انت بتحس فعلا you don't buy justice. ما بتخلي القضاة بتاعك يكونوا يعني جعانين عشان يكونوا ضعاف. you بتعين judges, you don't dismiss them so that they remain strong in their decisions. بتوفر لهم كل حاجات بتاعهم. لكن in the absence of this هو ده ولكن ده كله درس هو ورثنا بس يعني بدل الإثنيك بدل الإسلام الإجباري بقى بقينا في الإثنية الإجبارية والحيمنة الإثنية، ولكن كلهم قرأوا كتابة مسيرهم من الزوال إن شاء الله لمجال التاريخ. there's no way أصلا ما في أمة ما في الهيستوري علمنا الكثير we shall let us يعني مهما كان أحسن تعيش بالبسيط اللي عندك ده. شفت بكسرة وموية زي ما بيقولوا زمان لما كنا في السودان أو هنا والله مرات بس عيشها شفتها كده إن شاء الله يلا تعمل فيها عسل بس وتتغدى به you feel proud and happy as you تشارك مع جزء تاني مع شخص آخر داير علاج داير كده instead of we struggling عشان نطلع $100 يا أخي نطلع 1000. let us feel it. let us share the feeling بتاع struggle together إذا كان آلام وكده إذا كان ده هنقصر الطريق للسكند ليبريشن soon. dynamics العالم is changing. things are changing. things will never remain the same. لما بعدين this time نرجع أنا كان SPLM أنا بقيت SPLM بعد 2 weeks بس. لما الناس تانيين كانوا بيسمي كلاب بتاعهم جونجرن لما كان بضربوا جونجرن ببيت. لما كان زمان لو عرفوك انت SPLM في انت مشكلة دي زي جريمة. لكن تبدلت الأحوال ولكن هكذا التاريخ ستتبدل وتجي الحق. that time will come. هنقعد كلنا في كل 64 بدون exclusion of any other person ولا ضغينا ضد any جن الأصليين مثل جن كانسل الحرامية. دول استعملوا الاسم بتاع القبيلة عشان يغشوهم عشان يستغلوا الجهل. أنا لما وزعوني في أبر نايل وعليه الله يرحمه دينكاوي من بحر غزال دينكا بتاع بحر غزال قال لا هم دارين كور ما دارين عليه. that is the جنوب اللي كان هم they know أنا من إكواتوريا nevertheless قالوا لا نحن دارين كركر يوم يسمونه هنا كركر you know that time will come الاستغلال بتاع الحرامية will come to an end إن شاء الله chairman بس شدها ونحن تحت قيادتك مع كل هؤلاء هنحقق ده الزمن منكسر it will happen liberation is imminent أصلا no way.
Thank you so much, Justice Kukur. Thank you for your last submission. وهيدا تجيت متأخر لقيتنا خلاص محمد كمان جا لقيتنا خلاص. We have been sitting here for the past 2 hours and a half. We've exhausted what we wanted Justice Kukur to be talking about. Justice Kukur.
Yes.
أنت كنت ضيف عزيز علينا. أنا متأكد the audience, those who have been here right from the start and those who have come in the middle have listened to the things, all the الحيثيات اللي أنت رفعته, and they have loved it, and they've come to realize some of the things that they probably had different ideas when they read those charges, when it was laid out and it was produced in video and kalam da kullu. And then the document actually came out. They've come to realize some of the things that are not correct in that document. Thank you so much for being here, sir. I know it is getting late on your end, and I don't believe that I want to keep you here for anything else. A lot of for this interview was to educate rather than to interview, to question you. We are not here to question you. Instead, we put questions that we are putting together for you to try to help us understand what was it all about. And I hope that a lot of the members of the audience have come to realize exactly what this is all about. Geneva, my fellow brothers, Geneva, my compatriots, you've heard it from Justice Kukuru Lapita Marino Pitia, former judge of the Supreme Court, Judicial of South Sudan, the current member of NAS Leadership Council. The charges are legally weak, politically motivated, and destructive to the current peace process between the IG and the IO. We know that already. Justice cannot be selective. We have established that. Nor can it be turned into a weapon. And we have established that the regime has actually, by laying these charges in the way it is laid, they have weaponized the justice. Because Ham regime al-awwal wal-akhir is finding ways of how to get rid of Dictoriac, and Betali aksir shokab that Nuer Kagabila, and then Bagi Gabail Tarindel will follow the suit, the Kassir Shok Batam Betertib. South Sudan must choose either law or lawfare, peace or manipulation. We will continue to expose the truth every second of our life. Thank you, gentlemen. Thank you, Justice Kukur. You can take your leave now, because I don't believe I want anyone to ask you any question now. If there is questions to be asked you for something, we have to have a session for it. But this one has to sink into our minds, into our brains, as to exactly what happened. Thank you so much for being here. Justice Kukur,
Thank you.
You can take your leave. Mohammed just turned up, and Ohide just turned up. I can give ourselves 10 more minutes after Justice leaves the stage. You can make comments or you want to Then we will call it a night, a morning, a day, a morning, an evening, whatever it is. Justice Lukur, thank you so much. You can take your leave.
Shukran, compatriot Lion, Queen, and Justice Kukur. أنا داير أشكركم في المنصة والغرفة، وهو فعلا تعليمي صراحة كده. يعني قبل قاعد أسمع جاستس كوكور كان قاعد يقدم حاجات بيفيدنا كتير، ومن ضمن أدوات وذكر أدوات بتاع محاربة في جهاز القضاء ذاته كناس قضاء هم كيف يقدر يحاربوا المظالم اللي محتكروا النظام بتاع جوبا في تغييب العدالة وصناعة العدالة لنفوسهم هم المجرمين، وضعوا لنفوسهم حاجات ما بيقدر بيساعد البلد. وبرضه ذكر حاجة بيشير إلى إنه الناس تصحى، ناس الرجال القانون ده خليه يصحوا، خليه يعرفوا إنه هم الأمل في تغيير في البلد. لو ما قاموا صمتوا العدالة بيكون في يد السياسيين، والظلم بيسود فوق كل حق، وبالتالي هنبقى ضحية والبلد بيبقى ضحية. ده كلام اللي أنا فهمت من كلامات اللي هو قاعد يقدم تعليمي. فمن حقائق اللي هنا هسه اتعلمناه في الغرفة ده، بالذات في التسجيل الحسة في الغرفة ده، خليه يكون إبرة لأي رجل قانون بيعرف إنه يقود العدالة في مكانه الصحيح، لأنه في حاجات كتير غايبة في صحة بتاعت العدالة داخل وزارة العدل ذات. فتسييس المحاكم جزء من أدوات اللي النظام استخدمه، وده واحد من حاجات اللي هسه هو ذكره. نمرة 2 ده بيكون إضافة حقيقية لمنصات قدمناه قبل سنة أو سنة ونص الفات. كنا اتكلمنا عن محاولة بتاع الدخول بتاع النظام بتاع جوبا في إحدى غرف عن تسييس الكنيسة ذات، لكن كان في حتى صد عنيف لبعض القادة من رجال الدين اللي حاولوا إنه يتصدوا للمحاولات بتاع اختراق النظام للكنائس مجامع الروحية ده، وحاول إنه يخترقوا باقي. طبعا في رجال الدين في اوبورتونيست، وفي ناس اصلا جايين يخدموا ربنا بحق برضه. والتسييس بتاع institutions public institutions في ساوث السودان حيستمر، وكثير ما ذكرناه. ده جبال هنا رجعنا للتعليم بتاع جاستس كوكر هنا بيوريك انه اجد كلها اللي بيأدي اللي هو جهاز القضاء وزارة العدل، لأنه من هنا بيكون في أمل لصناعة السيستم اللي بيقدر بيدير جنوب السودان كسيستم ما كفرد يجي يحكم. هنا محتاجين لأنه يكون في سيستم يحكم جنوب السودان، مش يتسيد لجنوب السودان، ما يكون شخص هو اللي يتسيد. وده برضو أنا بجيف هنا ما داير أتكلم كتير، وبشكركم كلكم. وأنا قبل داير أشكر بس يعني 3 في المنصة. عايز أشكر جاستس كوكر في حاجات عليه أنا فهمت من تعليم اللي هو قدم كان حقيقة. شكرا لكم.
شكرا compatriot Wahida. Compatriot Mohammed.
Yeah, thank you, compatriots. Indeed, I came in the middle of the presentation, but what I have gathered so far has given me a little bit of insight. Since Justice Koko is one of those by then who were within the justice system in South Sudan, looking into what he said, indeed is true. It's just a reflection of ethnic judiciary system that if they really decided, as they said, that they're charging Rang Machar with all the crimes that they manufactured, and that is not going to stop anything else, and it's no longer a justice system. It's going to be a tribal court that you're already been presumed guilty, regardless of that sitting or not. And one thing that also I understood clearly based on this presentation that we really don't have a justice system in South Sudan. I'll be honest with you, because you cannot bring somebody to the court based on concorded allegations. Even a person that is not within the judicial system can really say that so is not guilty. It's just a lie. It's a completely wild lie that have been fabricated toward their opponent. And all is concluded in one thing: ethnically and politically motivated. And you put it right, Molana Lion, when you say that, they're just trying to test the Nuer as ethnic group. And is a really justice system, or that is a mockery of justice? For this, let the being who heard Justice Coco's presentation make their own call and make their own decision, because it's an educational purpose. And this is, by the way, I believe it's not the first and the second judicial case that have been brought before this so-called the judicial system of South Sudan. And it is sad that we have to reach to this point. But I hope that Maulana Lee, you can also make arrangement for Justice Kukur to come back and maybe educate, and maybe the South Sudanese will ask a question for us who have been never been to South Sudan since the creation of the so-called independent of the South Sudan. But just reading based on the documentation and the laws that temporarily pass in the parliament that is weaker, that is no check and balance. Nobody can oppose the system because all the three branches of the government is be rendered completely, especially two, have completely been rendered helpless because the power had been hijacked. So basically, the executive is now the judiciaries, the executive is now the parliament, the executive now is everything that they feel that they can do in the country. So if there's no check and balance, so this kind of mockery justice court will continue, which is leaning one side. So therefore, thank you for giving the opportunity, my brother. But please make arrangement for Mr. Koko to come back, maybe for South Sudanese to ask a question, so that there's some burning question that maybe somebody either might have misunderstood him when he says something, or somebody need a clarification on some laws in South Sudan. And this case of Ramashar is a test to all of us because it's come out as a testy case. Why? Because it's basically the system of Kiir versus Ramashar. And let us figure it out. Thank you for giving the opportunity. I yield back with the mic to you so that you can close and go to sleep.
We will get the justice to come back, as you suggested, for an open session where people can ask questions, because we will not have the questions, but people can ask questions in regards to those points you've raised. Tonight's show or this morning's show, or wherever you may be, and according to your time, was specifically about the charges laid against Dr. Riek and his colleagues. That's why we didn't have any space for people to come and ask questions. We were meant, the only intention was to explain and educate our people into what these charges means. And of course, one of the funny things that we've picked up is the article that was quoted as a basis for the charges against humanity, Article 206, which was completely something else, misquoted. So the question is, why would you're laying charges, a very serious charges against person? You will have to be 200% sure when you're quoting an article. You from the either be it from your penal code or from your constitution, make sure you're coding the correct article. Otherwise, it leads to miscarriage of whatever you are trying to do, because you have gone on and on and on and on just reciting that code, but then it comes to be talking about something else. So where are you coming from with the charges from? What is your base, your legal base for coding anything? So that was the only reason why we don't have questions tonight. But definitely we can arrange for justice to come back as someone who has been a judge in the Supreme Court, come and talk about all these issues that you've raised, and it will be finalized with fellow South Sudanese coming up to ask questions they want to ask to try to understand. Thank you so much for coming up with the suggestions. Compatriot Queen, are you still there?
Yeah, I'm still here. I have nothing much to say after what Justice Kurkur have educated us with. So I will just play the last song after you concluded your thought. And also, I want to thank everyone in this forum today. Please, if you just tune in or you came half an hour ago, just share the room with your friends, with your relatives, with the groups that you have. We need this message to reach our people that they are not here with us in Clubhouse or in live video on Facebook or YouTube. Actually, today we have played this in 3 different areas, which is YouTube, Facebook, and Clubhouse. So if you have your conclusion, Commissioner Danieli, then I will just play our last song and close the room. Thank you.
Thank you. I believe I've made my conclusion early on. We'll just say good night to those who are at nighttime, at the dark side of the world, and good morning to those who have the shiny side of the world coming up. And good day to those who have the sun is already up and they're going about their business. We will be meeting again, hopefully very soon, specifically with Justice Kukur, to discuss those issues that was raised by Compatriot Mohammed. And also, we may also be meeting with any other members, senior leaders, or any other eventual events that will come up, and sharing together. Thank you so much. Compatriot Queen, you can play the concluding song. Thank you.
Okay. Just let me know if this voice is clear.
Give thanks and praise to the Most High N and I for the people of South Sudan, you know. Let's come together so we can resolve our own problems. Peace and unity is more important to our country. Anagi asalo mushkila ta hakuma shuno. Ananina gi asalo mushkila ta hakuma shuno. Ananina gi asalo malitu majojibu salam. Ananina gi asalo lifu de kulu le shuno. Ananina gi asalo wito maju salam aliatu. Salam aliyatu Ananina mazin salam tashukul waziri Anina mazin tifakia tashukul naib rais Salam yakinu bin yatapanin kalamu simosulta wa mafi salam mushkila bitakum shuno Sante gidiongi asalo sa mushkila bitakum shuno Nagi asalo mushkila bitakum shuno Yakaya walangi asalo sa mushkila bitakum shuno Itukulu ya siyasi Ilmumini ya mutamalali Jahano nukani fulda Kulana Viram telephone Jahano nukani fulda Kulana Viram telephone Ninakale jahano nukani fulda Kulana Viram telephone Kuna wana suma shakil tepele Las Muhammad Nina wana sugati ya tajunu Kulana Sayal you Kuna wana suma shakil tepele Wani asalo nufus kagaman Mushkila da bada hinwe Kalina asalo nufus kagaman